Hey guys, Mr. Shaw here. Well, yeah, we got to go ahead and get through some notes today, but let's go ahead and start with celebrations. Anybody? Nothing? You're just going to embarrass me now? I see how it is. All right, well, anyway, I guess we're going to go ahead and get started. So, judicial branch, third and final branch of the federal government. Let's get right to it. So in Article 3 of the Constitution, that establishes just the Supreme Court. Okay, put a star by that one again. That's really important. Again, that is the only court that is established in the Constitution. And Congress is the one that has the power to establish the lower federal courts. So that's exactly what they did. In the Judiciary Act of 1789, they established those federal courts and the circuit courts of appeals. So there's not every state has an appeals court. If you want to, again, like the appeals court, only kind of like they're on a circuit that's it's like traveling, not necessarily traveling, but again, you would have to go to a certain area in order to appeal your case. Again, I have a map of that later. So anyway, there's three main levels now. We have district courts, which are going to have your normal like trials cases that you're going to see on the Law and Order type shows. We have the circuit courts, which are the courts of appeals. Again, so if you lose in the district court, you can appeal your case to the circuit courts, the appeals courts, and they will take a look at your case. Again, we'll talk about that later. And then if you lose in the appeals court, you can appeal to the Supreme Court to look at your case. And if they only look at cases in very special instances. And again, we'll look at that a little bit later. So Article 3 also gives federal courts what's known as jurisdiction. Okay, this is the authority to hear and decide a case. Again, make sure you get down the definition there. And federal courts have jurisdiction in the following. They have when it has to deal with the Constitution, any federal laws, any disputes between states, citizens from different states, the federal government, if it has to do with the federal government, any foreign government, and treaties, any maritime laws, and anything involving U.S. diplomats. So the Supreme Court, actually, it's actually kind of funny. There's a if any trial that has to do with pirates or anything happening on the ocean that are like in U.S. waters, that actually is heard by the Supreme Court because it didn't take place in any one state. Every state has their own district courts, but if something happens in the water, again, that's not in any particular state, so the Supreme Court would actually have to hear that, or the federal court rather. But again, that would probably take place in the Supreme Court because there are federal courts, in the same districts that we're going to be talking about. But anyway, so that's where the federal courts have jurisdiction. Anything else is going to fall to the states. So if there is a dispute between citizens of two states, again, that is going to go to state courts, which are not, again, these are not state courts. Okay, the district courts these are all federal examples of courts. So we have two types of jurisdiction. We have exclusive jurisdiction and then concurrent jurisdiction. What exclusive jurisdiction means that basically when the federal government has the only jurisdiction. So literally, only the federal courts can hear and decide cases that are over like federal law or like constitution cases. Anything that has to deal with that, everything that I had on the last slide, that the Article 3 gives them the jurisdiction over, that is exclusive jurisdiction. Those can't be tried in state courts. We also have concurrent jurisdiction. That is where both federal and state courts have jurisdiction. Either court, federal or state, can try these crimes that violate both a federal and a state law. So again, those are going to be very much more specific. So for example, if you are tried, for example, like treason is something. If you are plotting to kill the president, that is treason, and that would be tried in a federal court. Okay, but if you had, like, for example, the states set all the speed limits, so they would, if you break the speed limit, you would then go to a state court. And then there's going to be different examples of ones that have concurrent jurisdiction as well. And just finishing up explaining that, again, also the states and federal courts have concurrent jurisdiction when there are citizens of different states involved. And also if there is something involved with, like if there's a dispute with over $50,000, again, that can be either done in a state or a federal court, and either party can ask or can request, for their case to be tried in a federal court rather than a state court. Okay, so our court system, again, we talk about the U.S. District Court. Again, this is where everything begins. Okay, this is where, if you are going to trial, okay, this is where you start. Is at again, this is only at the federal level, not at the state level. Okay, again, so something like breaking the speed limit. Okay, if you have to go to court for that, again, that's a state court. But for example, if you are accused of murder, okay, again, or robbing a bank or something like that, again, that's a felony, and that would be tried at a federal court. Again, there are district courts in every state, including the District of Columbia. There are currently 94 district courts, and we also have two versions of specialized district courts. One is the U.S. Court of International Trade, and the other one is the U.S. Court of Federal Claims. Again, so the first one is going to deal kind of with commerce, and if there's any issues with commerce or trading with other countries, again, that court would try those cases. And then the federal claims, again, that can have anything to do with money or land. The federal government has a claim over, and that would go to federal court that would go to that specific court as well. Again, the district court have what's known as original jurisdiction. So this is the authority to hear cases for the first time. What's interesting about that, guys, is that the appellate courts or the appeals courts and then the Supreme Court, there very few cases are you're never going to have an actual trial happen in the Court of Appeals. You might in very rare cases for the Supreme Court, but this again, this is where in the district court, that's where you're going to have your very standard trials that come to mind when you think of the shows like Law and Order. Again, that only really happens at the district court, and that's what original jurisdiction means. The appellate courts, again, are also known as the appeals courts. They have appellate jurisdiction, which is the ability to hear a case that was appealed from a lower court. So when you go to a district court and they make their decision, okay, the jury, the jury makes their decision, and you can appeal that. And if the appellate court or the appeals court decides to hear your case, then again, you don't redo the whole trial. All they do is they review the transcript, which is just the recording, there's a person typing the entire time during the district trial. So they review the transcript of the trial court's proceedings. The attorneys are present, and they give arguments as to why the decision should or should not stand. So that, again, you're really not, you don't have to be present in your appeals or for your appeal. Again, it's just kind of the lawyers. It's not, again, you're not retrying the case. They're just looking to see if anything is wrong, anything that that took place in the trial shouldn't have. Anything like that. This is not a jury court. Again, there is a panel of 3 or more judges that look at your case, and there are 13 of them in the United States. And again, there's 12 regional, and then 1 is a federal circuit. So again, you see we have 12 here, and then there's 1 that is going to kind of just be traveling as well. And that might have actually been an old map because I only saw 11 there. But anyway, there's 12 now. So again, we talked about, I wanted to kind of just make sure that we understood the whole, the whole making the decision part of the appeals court and what actually happens in that court. Appeals courts can make one of 3 decisions. First of all, they can uphold the original decision, they can reverse the original decision, or they can remand the case. I want you to add something for me right here. I need you to draw an arrow off of the word remand. That means send back down. Okay, so they send the case back down, okay, to the lower court to be tried again. The appeals courts or the appellate courts, they are going to offer an opinion, and this is going to be a detailed explanation of the legal thinking behind their decision. And so what is going to happen here is that with these appeals courts and these district courts, they are going to set precedents. And it's not really necessarily for the district courts, it's more for the Supreme Court and the appeals court. What they'll do is they will give, when they make a decision, that like if there was a decision that is made in the past and there's a case that's exactly like a previous case, a precedent states that the judge should, the judge or the ruling should coincide with the past judgment. So that's what precedent means. So whenever if there's one case that's exactly like a current case that was in the past, then that whatever that judge said, that precedent should be followed, unless that precedent is was made in error, or they no longer believe that precedent should be followed. But again, your definition here of precedent is, again, that gives guidance to other judges by offering a model upon which to base their own decisions. Again, they don't have to, but again, they usually do follow precedents, just because, again, that is like the law is supposed to be pretty stable, and only in times of great upheaval, like when for Brown versus Board of Education, where they desegregated all of the public schools. That's an extreme case where they did not follow precedent because they thought that the precedent was flawed, and so they decided to change it. Okay, federal judges. In Article 2, Section 2, it provides the President with the power to appoint federal judges with the advice and the consent of the Senate. Again, we already knew that. We knew that the President appoints them, and we know that the Senate approves them. Federal judges get something immediately known as tenure, which is that they can only be, once they are appointed, they can only be removed through impeachment. You can retire. Again, you don't have to stay the whole time. Most judges do, but for example, there are 2 judges that have retired but are still living, and you might retire once you don't really think that you can perform your job adequately anymore. But again, most judges will stay until they die. Again, Judge Antonin Scalia being the most recent example of that. He passed away in last February, and again, he kept his job throughout the rest of his life. There are other court officials as well. We have magistrates, which are going to do routine work, court orders, and they'll also hear preliminary evidence, etc. Again, they're just kind of like they just kind of support the whole system. They'll make sure that things are kind of going smoothly as they should be. We also have U.S. attorneys. Again, these are government lawyers who prosecute people accused of breaking federal laws. So again, the Attorney General would be the head of all of those lawyers, and again, it's not like just one big group of lawyers, but they do have, there are federal lawyers that are literally just work for the government. So if the government needs, a lawyer to try a case, they will go to these attorneys that are just there for only that purpose. We also have U.S. Marshals. These are basically going to be like the judicial branch's enforcement officers. If you've ever seen Justified, that show that's on FX, again, he is a U.S. Marshal. Again, he works for the federal court system. They are going to make arrests, collect fines, and then take convicted persons to prison. Okay, so the last one is the Supreme Court. Again, that's the highest level of the federal court system. Again, that was established by Article 3, Article 3 of the Constitution that we already talked about. And as I mentioned before, again, the Congress is empowered to create the inferior courts if necessary, and we know that they already did do that with the Judiciary Act of 1789. There are usually 9 justices. There's 1 chief and then 8 associate judges. Currently, we only have 7 associate judges. And again, they have original jurisdiction in very unusual instances. Like that, again, remember, original jurisdiction means that they can try a case first or hear a case first. And again, like the example I gave you of the piracy or the pirating, again, that would be an example of something that the Supreme Court could actually hear that trial first. But again, most of their jurisdiction is going to fall under the appeals jurisdiction or the appellate jurisdiction. Okay, guys, I've reached 15 minutes, so I'm going to go ahead and stop. The rest will be in another video. Thanks for watching. See you next time.